Unwired Planet versus Huawei Supreme Court decision. My name is Axel Frazzini. I'm the Managing Director of 4IP Council. As you may already know, 4IP Council is a not-for-profit research council developing high academic insights and empirical evidence on topics related to intellectual property and innovation. On 4IP Council's website, we offer an extensive body of research addressing current intellectual property and innovation themes. This includes webinar recordings and papers addressing the CJEU ruling on Huawei versus ZTE and related questions. Another popular resource we offer is a library of case summaries covering national court decisions following the ruling. Please click Stay Informed on the right side of our homepage to be informed of new cases, research, and future webinars. We are also committed to encouraging innovative SMEs to use IP to grow their businesses, and we provide a range of resources to help them achieve this end. We will upload this webinar and the slides free of charge following the presentation. Richard Very will take questions after his presentation, so please feel free to use the Q&A tool that you should be able to see on your screen and not the chat window. Please allow me to briefly introduce you to our great speaker, Richard Very. Richard is a partner in Bird&Bird's intellectual property practice and tech and communications sector group. He specializes in multi-jurisdictional electronics patent litigation with a particular focus on mobile telecommunications patent litigation and arbitration work. He also has extensive experience of dealing with IP in transactions and strategic IP advice. This is an honor to have you, Richard, today. And without further delay, the floor is yours.
Thank you very much, Axel. If you could pass me the control, I can start sharing. Here we go, sharing the slides. Can you now see a slide with with the background and Unwired Planet and Ericsson on?
No, we can't.
Okay, I'm getting a message saying some files are damaged, reinstall WebEx. Axel, would you perhaps be able to go straight to that slide? And yes, perhaps if we do it that way, that you share the slides for me. I'm sorry, I obviously have some problem.
Yes, hold on.
Perfect. I apologize for that slight tech problem. So it's finally happened. We have spent most of the year speculating on when this judgment would come out, and I remember being asked around December time by various clients, when do you think we'll get the Supreme Court decision in Unwired Planet? And I thought, well, 3 or 4 months probably wouldn't be unreasonable, so I thought maybe early in the new year, and then it was going to be later in the new year, and then we thought it had to happen at least before the end of July, because by the end of July, the courts all go on holiday and the Supreme Court probably wouldn't be handing it down. But I think what happened was that the English Supreme Court got together with the German Supreme Court and the Mannheim Court, and they all decided that they were going to hand down their big Franz judgments that everyone was expecting right in the summer holidays when we'd all just packed up and gone away, so that they'd catch us when we were out of the office, and that's exactly what they've done. So we finally got it on 26th of August. If I can remind you of how we got to this point, it all started back in January 2013, which now seems like a lifetime ago, when Ericsson sold 50 patent families to Unwired Planet. There was a settlement with Lenovo in March 2014, where some patent families were sold and others were licensed. And in March-April 2014, Unwired Planet brought litigation against Samsung, Google, and Huawei. Google settled out fairly early. Samsung hung on in the litigation for quite a while, but then settled out in July 2016, taking a license, and that left Huawei as the only person defending who went to trial. An important point here, which is going to come up later, was that when Unwired Planet sued in April 2014, it hadn't first made the offer, provided the claim charts, all of the sorts of things that we now regard as normal under step 1 of Huawei and ZTE. But the other important point is that Huawei and ZTE didn't exist back in April 2014. Do you want to move to the next slide, Axel?
Can you see the change? Richard, we cannot hear you.
I apologise to everybody for that break. So the first instance decision was an analysis of Huawei's FRAND defence, and Huawei's FRAND defence was partly in competition law and partly in contract law. And the FRAND defence in contract law was that as an owner of standard essential patents who has made a commitment to Etsy to license those patents on fair, reasonable and non-discriminatory terms, that created a binding contractual obligation on the patent owner as a matter of French law, which could be legally enforced against him by an implementer. The English court agreed with that theory. If you could move to the next slide, Axel. So in competition law, the argument was as follows. Unwired Planet holds a dominant position by virtue of being an SEP owner. Unwired Planet was said to have abused that position by Huawei by declining to offer licenses on fair, reasonable and non-discriminatory terms, and by not following the Huawei and ZTE four-step licensing process. And Mr. Justice Burst decided that as a matter of competition law, although they held a dominant position, they had not abused that dominance, because the Huawei ZTE scheme was a safe harbour. It didn't mean that an abuse had taken place merely because the patentee didn't follow those CJU steps. It also, of course, is relevant that the Huawei ZTE case and those CJU steps post-dated Unwired Planet's starting of the proceedings. So one of Unwired Planet's objections was that they couldn't have followed the steps because the steps didn't exist at the time. Mr. Justice Burst found that Unwired Planet's offers made during the negotiation were too high. They were not FRAND. But he found that high offers made during negotiation are not an abuse, so long as they don't disrupt or prejudice the negotiation. In other words, it's to be expected in a negotiation that one side will make a high offer, one side will make a low offer, and you will end up somewhere in the middle. It's not an abuse of dominance position not to start in the middle, to start apart and with the intention of ending up in the middle. So next slide. As a matter of jurisdiction, the question arose, can the English court determine the terms of a worldwide FRAND license? What you'll remember is that Mr. Justice Burst had set out to find what a FRAND license was. He found that parties negotiating in this area would generally agree a global licensing scheme. He looked at the licenses that had been offered by Unwired Planet, and there was a global one. There was a UK one. Unwired Planet had said, we prefer the global one. If we're not entitled to a global offer, then we will offer on a UK-only basis, but our primary case is that this should be global. And Mr. Justice Burst determined for himself what a fair, reasonable, non-discriminatory global license would be. He found that the English court can determine that because that is merely recreating what the parties to a license agreement would ordinarily do. and that this was not some sort of expansion of the UK jurisdiction to look at foreign patents or to look at overseas validity or infringement of patents that are outside the UK. It was merely a question of determining what a fair, reasonable and non-discriminatory license agreement would be agreed between the parties, and the English court was able to do that. And then he found that if an implementer then declined that license, he could go ahead and grant an injunction against infringement of the UK patents in the UK. And that was within the jurisdiction of the English courts. And then the next one, Axel. On a question of valuation, this, to many people, is the most interesting part of the whole case. Theoretically found there's only one set of terms which are FRAND in any particular case. In other words, FRAND, he found, was not a range of values. It could be approximated to a single value, and therefore it's something that a court can determine. One way to look at it would be to look at benchmark rates, which might, for example, be set using comparable licenses. Look at other licenses that have been entered into. In this case, he had a whole suite of comparable licenses because the patents had formed part of Ericsson's portfolio. And he could use those to determine what a fair, reasonable and non-discriminatory rate might be for a license to the Ericsson portfolio. And the parties had then agreed what sort of subset of the Ericsson portfolio the Unwired Planet represented. And that could be then used. If this had been a situation where there were not many comparable licenses, he would have had a rather more difficult task on his hands, but he was able to use this previous suite of licenses that covered the patents when they were part of the Ericsson portfolio. And then he used the top-down approach as a cross-check. So next slide, Axel. 3 points were appealed. Unfortunately, there was no appeal on the valuation aspect of the license agreement. And that was a shame because there were many aspects in that were then also tested in TCL and Ericsson in the United States. And the United States court and TCL and Ericsson reached slightly different conclusions on many of the points. And it would have been interesting to see what an appeal court thought of those. There was one particular point that I think both sides would agree had been a clear mistake, and that was that what Mr. Justice Burst determined for Ericsson was a global blended rate, in other words, an average rate for the Ericsson portfolio licensed across the globe. He then determines that that wasn't necessarily appropriate in this case, and there should be different rates in different jurisdictions. And he went about that by applying discounts to the global blended rate. But of course, if you have a global blended rate, that's an average. And if you try and unpack it into lower value countries and higher value countries, you can't just apply discounts without also looking at what happens at the other end. Mr. Justice Burst didn't do that. That wasn't appealed, and it would have been interesting to see what the Court of Appeal said about that, but that was missed. Instead, there were only 3 points appealed to the Court of Appeal. First of all, can the English court engage in an exercise of global licensing? In other words, can it look to see whether what a global rate would be, even though that goes beyond the exercise of looking at English patents and what a UK court might award in respect of English patents? The Court of Appeal upheld Mr. Justice Burst on that for reasons that we'll get into it when we get onto the Supreme Court. The second question that was before the Court of Appeal is this issue of non-discrimination. Do you remember earlier on we looked at Samsung settling out before we got to the trial? Samsung had settled at a rate which was lower than the rate that Mr. Justice Burst had awarded Huawei. And an argument arose from that, which was that if Samsung had a lower rate, why was Huawei's higher rate still non-discriminatory? In other words, is this test of non-discrimination hard-edged? Does it effectively mean that if somebody else gets a lower rate, then you are entitled to it? Or is it a more general obligation? What Unwired Planet had argued at first instance and argued at appeal was that this test of fair, reasonable and non-discriminatory was a single unitary test that covered that you had to read all parts of it together. You didn't ask, first of all, what's fair and reasonable. Secondly, what is non-discriminatory? and whichever of those was the one was the rate that the implementer would be awarded. The Court of Appeal agreed with the first instance judge on this and with Unwired Planet on this. It found that the test of non-discrimination had to be read as part of a whole test of fair, reasonable and non-discriminatory. And if a rate had been set that was fair and reasonable, and that was offered then to the new implementer, then that would of itself be not discriminatory because everybody's being offered a fair and reasonable rate. That was criticised by some people. They couldn't see how the non-discriminatory obligation had any effect whatsoever. But the Court of Appeal also looked at the test the other way around. They said if the non-discrimination test dominates this, then what it effectively is a most favoured licensee clause. In 1993, ETSI had looked at whether to have a most favoured licensee clause as part of the ETSI IPR undertakings, and had decided not to do that. So if we now read the non-discrimination part of the test as being hard-edged and being requiring a lower level than a level that might be fair and reasonable, then you would effectively reintroduce that most favoured licensee clause by the back door. So they decided as a matter of contract law, you couldn't interpret the obligation in that way. And so they decided it was not a hard-edged obligation. The third question was, does Unwired Planet need to comply with those Huawei and ZTE steps? The Court of Appeal said no. They were more like guidelines. They were a set of criteria by which to assess the behaviour of Unwired Planet in granting its licensing. And it was important also to remember that this was a transitional case. It was a case before Huawei and ZTE had been decided. So they had found that Unwired Planet, it did not matter that Unwired Planet may not have complied strictly with those tests. So if we could move to the next slide, Axel. The case when it got to the Supreme Court was then combined with Conversant versus Huawei and ZTE, which was another UK case. The background to that was that Conversant had purchased about 2,000 patents from Nokia in 2011. 28 patent families of those were claimed as essential, and it had asserted some of those against Huawei and ZTE in the English court. It asked for a declaration that its offer was FRAND, or a determination of FRAND terms, and Huawei and ZTE challenged the jurisdiction. A big difference in this case and Unwired Planet was that they challenged the jurisdiction right at the outset, and not only by the time they got to trial. So they challenged on two bases. The fact that this involved an assessment of the validity of foreign patents, which is the same basis that Huawei was arguing before Mr. Justice Burse. But a second point which arises for Conversant because they made the challenge right at the outset, but didn't exist for Huawei by the time they got to trial. And this is this test of whether the UK is forum conveniens. In other words, if there are two forums that could hear this case, is the UK the one that is best suited to it, or is there another forum that is more suited to hear the case? And if that's raised at the outset, that can be a reason for the English court to decline jurisdiction, set aside service out, and then stay the case in perpetuity. So next slide, please. Mr. Justice Henry Carr dismissed those jurisdiction challenges, but he did give permission to appeal. He dismissed the challenges on the basis that the English court does have jurisdiction to enforce the ETSI contract, that the correct way to look at this, what the English court was being asked to do, is it's being asked to grant an injunction in respect of English patents or UK patents within the United Kingdom. The question of what is a FRAND rate for the entire portfolio arises effectively as part of the defence to the injunction. It's not necessarily it's not the question that is primarily before the English court. Now, in Conversant had asked up front for a declaration, as a determination as to what the FRAND rate was, but Mr. Justice Henry Carr saw this merely as anticipating a defence that was bound to be raised. So they were the FRAND question still arose as part of a defence to an injunction. It wasn't the primary question that the English court was being asked to determine. He had evidence before him as to whether the Chinese court would be more suitable, but the evidence at that point was not strong, and he considered that it wasn't strong enough for him to determine that the Chinese court was a more convenient court to determine the action. He did, however, schedule the trials so that by the time the UK court got to trial on Frand, a number of issues would have been determined in the Chinese case when it got to trial. So he did take some account of that. The matter was appealed to the Court of Appeal, and the Court of Appeal agreed with Mr. Justice Henry Carr on those. So this case also went up to the Supreme Court along with Unwired Planet. Next slide. So the Supreme Court had some questions before it. First of all, does the English court have power or jurisdiction, or would it be a proper exercise of that jurisdiction to grant an injunction restraining infringement of the UK SEPs unless the defendant enters into a global license under the multinational patent portfolio? So that's the key question that we had, the question 1 that was referred to the Court of Appeal. Can it then go on and determine rates and terms for such a license and declare that they're FRAND? Then the second question, would England be the proper forum for such a claim? Now this is the point that was relevant to the conversant proceedings and whether the conversant can go ahead, but wasn't open to Huawei and the Unwired Planet proceedings because it wasn't raised early enough. Then what's the meaning and effect of the non-discrimination component of the FRAND undertaking? And does it mean that the same license terms as offered to Samsung must be offered to Huawei? That was the second question that the Court of Appeal was looking at, whether the non-discrimination element is hard-edged. And then the third point, should Unwired Planet have followed the Huawei ZTE steps? And does the CJU's decision effectively restrain or prevents the court from granting an injunction in the circumstances that we had in the Unwired Planet case? But then there was an additional question raised only at the Supreme Court, which is unusual to find, but it's been allowed in this case. And that was whether the court should anyway grant damages in lieu of an injunction just as a matter of its discretion. Next slide. So on that first point, Huawei argued that the imposition of a global license on terms set by the National Court would be wrong in principle. And the reason is that the question of validity, infringement of foreign patents was a matter for foreign courts, and that in determining the rates of a global license, what the court was doing was effectively making findings as to validity and infringement of foreign patents. Mr. Justice Burst had decided that it was industry practice and custom to determine that global licensing was entered into, and that finding of fact was not overturned in the Court of Appeal or by the Supreme Court at all. The Court of Appeal had looked at case law from other countries. One of Huawei's arguments was that the English court, by determining global rates, was out of step with other countries. And the Court of Appeal looked through this in quite some detail. The only case that they found in which suggested that it would be inappropriate to determine a global rate and that courts should be confined to national rates was a finding of the European Commission in the Motorola and Apple decision. Many other decisions that they looked at had seen courts determining what global rates were, sometimes by consent of the parties, sometimes not by consent of the parties, but as part of determining whether to grant an injunction or not. By the time we got to the Supreme Court, there were more cases that had determined that, and there's a fair chunk of the Supreme Court judgment which goes through looking at various cases in other courts and deciding whether or not those are inconsistent with what Mr. Justice Burst did. The Supreme Court found that, the Supreme Court upheld both the First Instance Court and the Court of Appeal on this. It agreed that with the Court of Appeal that the correct question that was being asked here is what is whether to grant an injunction based on UK patents covering the UK. It agreed that that was a matter that was within the jurisdiction of the English courts. it agreed that the imposition of a global license, sorry, not the imposition, the assessment of the terms of a global license was something that was within the power of an English court to do, because what it was doing was applying, was effectively construing the ETSI contract. The ETSI contract clearly envisaged that there would be licensing of on a global basis. The question that it was being asked on the ETSI contract was whether the license, whether this should be done on a patent by patent basis, and therefore country by country, you look at each patent and determine what the FRAND rate should be, or whether it should be on a more global licensing basis. And the Supreme Court decided that the licensing scheme was intended to be global. The correct interpretation of the ETSI contract was that a court, any court, the UK court being one of those, could determine what a FRAND rate was on a global portfolio. Mr. Justice Bird had also looked at this as a matter of practice. As part of the cross-examination of a Huawei witness, it was put to the Huawei witness that it would be prohibitively expensive to go country by country, patent by patent, and determine what a FRAND rate was for each patent. And Mr. Justice Bird relied on that to find that two multinational companies would not license on a country by country basis, and that the only reasonable thing for the court to do in those circumstances is also not to go on a country by country basis. The Supreme Court reflected this. This was Mr. Justice Bird's comment that licensing on a country by country basis would be madness, and that's found its way into the Supreme Court judgment as well as the Court of Appeal judgment. So if we could have the next slide, please. So assuming that the English court does have jurisdiction to determine this global rate, was England the proper forum to bring the claim? And this matters for the conversant case, if not the Unwired Planet case. And the Court of Appeal here, again, had looked at what was the dispute before the English court. And it was a claim for the injunction of the UK patents and an injunction under those patents. It was not a question of what was the determination of the FRAND license. The Supreme Court agreed with this as a first point. It found that the English court was a proper forum for the determination of what should be done about the infringement of UK patents. There was a second question, though, on this, which is, in order to determine forum conveniens, you have to decide, or forum non-conveniens, that the UK is not the most convenient forum. You have to find that there is another court that is more convenient in which it is to bring the case. The evidence that Mr. Justice Bird and the Court of Appeal had before them had primarily been aimed at China. The High Court and the Court of Appeal had both found that the evidence that China was a more convenient forum was not strong enough to make out that argument, and the Supreme Court agreed. At the time, it had been argued that the Chinese court was not able to determine a global rate and would not determine a global rate, and that was a finding that was then relied on by the Court of Appeal and by Mr. Justice Henry Carr in deciding that the UK court should go ahead. The third issue was whether the UK court should allow the Chinese court to go first, whether it should issue, just as a matter of case management, a stay of its proceedings. And that was a balancing exercise. The arguments in favour of it was that if the Chinese court had determined what a FRAND rate was for China, then that would be highly informative for the English court in deciding whether the parties had made FRAND offers, and therefore whether that should be taken into account in granting an injunction, because it would then have a big piece of the jigsaw puzzle already solved for it. The argument against that, of course, is that if you wait, the longer you wait, the longer the patentee is being kept out of any royalties, and the more patents start to expire. And particularly when you have an older patent portfolio where there's been a long period of negotiation before you start the court proceedings, and then the court proceedings take quite a long time, you are going to get to the point where patents start to expire. So as a matter of case management, there was a balancing exercise to be struck, whether you should stay the English case and wait for China to make its decision, or whether you should press ahead with the UK case. And what Mr. Justice Henry Carr had done was arrange the timetable so that some of the matter could be decided in China, and schedules the UK Franz trial for a date after that. And the Supreme Court found that it couldn't criticise Mr. Justice Henry Carr in doing so. That was a reasonable compromise. It was somewhere between a complete stay of the English proceedings and just pressing ahead regardless. And that was the correct thing to do in the circumstances. But that's a very specific point on this case. It may well be that an English court in future does stay the case to await the outcome in another jurisdiction if that's going to be useful and if it's going to be timely. Or it may be that the English court presses on ahead if patents are about to expire and if the evidence is that the case in the foreign jurisdiction will take very much longer. So next slide, please. So the final question is non-discrimination, sorry, no, this isn't the final question, this was the third question before the Court of Appeal. Is non-discrimination hard-edged? The FRAND undertaking, the Supreme Court found, was a single unitary obligation that license terms should be made available which are fair, reasonable and non-discriminatory. That's not two separate obligations, and still less did the Supreme Court say were there three distinct obligations, that fair was one test, reasonable was another test, and non-discriminatory was a third test. And it found this for very similar reasons to the Court of Appeal. It found that it liked the evidence that was put forward about the ETSI consideration back in 1993 of whether there should be a most favoured licensee clause. It decided that that was not the correct interpretation of the ETSI contract as to whether, and therefore that the ETSI contract should be interpreted as a whole. And on that basis, it upheld the Court of Appeal's decision on the finding that non-discrimination was not hard-edged, and therefore that the Samsung license should not serve as a cap, and that Huawei could not be awarded a higher amount. There was a separate argument on this based on competition law. One of the Unwired Planet's arguments based on competition law was that non-discrimination or discrimination was acceptable so long as it did not have some sort of effect that would discriminate against, would cause a noticeable distortion of competition, and that there was no evidence in respect of that. The Supreme Court found it didn't need to decide that point because it had already upheld the Court of Appeal and the First Instance Court on the basis of an analysis of the ETSI wording and as a matter of contract law. Next slide. So on the question of the Huawei and ZTE steps, the Supreme Court again noticed that this was a transitional case. It looked at what the discussions had been between the parties as part of the case, and the question of whether Huawei was a willing licensee and whether effectively Unwired Planet was a willing licensor. Now, Unwired Planet had not made an offer beforehand, but when it bought the case, what it had sought was an injunction or a determination of what a FRAND license would be, and if Huawei took the FRAND license, then there would be no injunction. Now, that is not quite the same thing as making a FRAND offer beforehand, but the Supreme Court found that as a matter of conduct, Unwired Planet had agreed to subject itself to the determination of a court as to what a FRAND license was. In other words, it was prepared to license patents at a FRAND rate, whatever FRAND might be, whatever a court or whatever an independent tribunal decided FRAND might be. It noted that as part of the Huawei and ZTE case, the Supreme Court had considered that as one of the tests. If a party is prepared to allow an independent third party to determine what a fair, reasonable and non-discriminatory license should be, then that was evidence of willingness. In contrast, it looked at Huawei's behaviour, and it had said that what Huawei had done was accepted a national license, but it had refused the determination of a global license. Since all of the courts had decided that a global license in this case would be FRAND, it found that on the Huawei ZTE test, Huawei itself might not have been a willing licensee. Therefore, if you look at those two factors, it found that the conduct of the two parties was such that favoured Unwired Planet getting an injunction and disfavoured Huawei being able to avoid an injunction in this case, even though there hadn't been a strict compliance with the Huawei ZTE steps in the way that you see analysed in the German cases. So that suggests that the Supreme Court is upholding the Court of Appeal's view that the rules are not, that the Huawei ZTE steps are not to be followed absolutely literally, but they are an indication of the conduct that is to be examined when you're deciding whether or not to grant an injunction. Now, that suggests to me that the Supreme Court is not saying that the Huawei ZTE steps don't apply. It's not saying that the Huawei ZTE steps are mere guidelines, but it is suggesting that they are indicative of a course of conduct, and that they should be taken into account in assessing whether an injunction should be granted, and that the English court will carry on doing that. So next slide. This final point is whether damages would be an adequate substitution for an injunction. The English court has always had a discretion to award damages as an adequate substitute for an injunction, and there have been cases about that. And there were some recent cases shortly before the Supreme Court decision, sorry, the Supreme Court hearing, where the English court had looked into that in other circumstances. The Supreme Court weighed up the balance on both sides. It understood that a threat of an injunction could be used by a patent owner to force an implementer to take a license at a rate that is above FRAND. It could be used as a severe weapon to implement holdup. But it felt that in this case that was not realistic, because the ETSI IPR policy does prevent an SEP owner from demanding exorbitant royalties, and if he does try to do so, and if the matter goes to trial and the judge is faced with deciding whether or not to grant an injunction, of course he's not going to do so if the SEP owner has not made any sort of FRAND offer, and he's not going to do so if without himself determining what a FRAND rate is and offering that to the infringer. So the reality is that the threat of an injunction is not a weapon in the hands of the SEP owner which can be used to extract an exorbitant royalty. On the other hand, if the court were merely to award damages, that would not prevent holdout, which would be a very real problem given the impracticability of suing in every country around the world where the SEPs were owned. So the Supreme Court carried out effectively a brief balancing exercise of the sort that would normally be carried out by a court of first instance in deciding whether or not to do this, and decided that damages in this situation would not be an adequate substitution for an injunction. It also had a look at the eBay case and considered that the eBay case was not necessarily the eBay case was not inconsistent with this. Now, it happened that in that case the court had made a decision in the other way, but looking at the factors that were being considered there, it was not inconsistent that in this situation the court would exercise its discretion in the other direction. So next slide. Now, how's the decision been received? I dug out a few headlines that were in the various news articles, and I thought I'd share them with you. Many of them reflect that this is very positive for SEP owners. So IAM describes it as another boost in a summer of notable highlights. FT says it hands an advantage to the patent holders. It's been described as a win for David over Goliath. It describes the UK as becoming the hotspot for SEP and FRAND litigation and reducing instances of holdout. But it's not been entirely one way. There have also been comments that suggest that this is not entirely positive. Foss Patents and Florian Moller is quite open to say that he'd hoped that the top UK court would reverse the prior decisions by the lower courts, and he's probably not alone in that in the implementer camp. Damien Girardin, who is a professor in Brussels, had noticed that the Supreme, or courts seem to be more concerned about the ability of the SEP holders to monetize their patents and the risk of hold-up. I think what he's talking about there is that there was a balancing exercise carried out, and the Supreme Court did come down in favour of the SEP owners over the implementers in that. Keystone Law questioned, is this actually a victory for IP holders? It makes 2 points. It first of all suggests that actually we may see some sort of retaliation from other courts. There may be a race to the courthouse. We may find that other courts are determining FRAND royalties, and that's being done by courts that are more friendly to implementers or may have a political agenda that's more favourable to implementers. And the second point it points out is that Huawei may no longer be selling in the UK, and Huawei is now a very large patent owner, and this in fact may be a victory for Huawei rather than a defeat. And then there are 3 comments by the 3 of the people who were particularly involved in this case, Andrew Sharples and Gary Moss from EIP, and Artie Rajendra from Osborne Clarke, all of whom were on the winning side in this case. And I put those up because I thought it reflects the human side of this, that there has been 7 years of this case that has gone on through 3 levels of court and has been a complete life-changing career-changing path for a large number of people who have been involved in this. Gary describes it as an epic journey. When we started on this journey, little did we think that we'd end up in the highest court of the land with the eyes of the profession upon us. And he's absolutely right. And Artie Rajendra, we are thrilled. I imagine that she wrote that after, or I hope that she wrote that with a glass of champagne in her hand. So next slide. What effect will this have? Well, I suspect that may be in some of the questions that we've got coming up. But I think the Supreme Court has merely upheld and reinforced the position that we were starting to suspect would be the case in the UK. And a large number of cases have already been filed in the UK, anticipating that the Supreme Court would uphold the Court of Appeal. So I'm not certain that the effect is going to be immediate or that large. It merely confirms what a lot of people thought was going to happen. But long term, we shall have to wait and see. But I'd be interested to see some questions, Axel. What have you got?
Okay, thank you very much, Richard. It was very interesting. So we have received many questions, and for the sake of time, I will start with the first one that we received. It says, after Brexit, do you expect European courts to respect the English court's jurisdiction over licenses to, say, German or French patents?
Yes. This confuses, I think, one of the arguments that was being made by Huawei with what the findings of the court actually were. What the court has said in this case is that the English court is, of course, not exercising any jurisdiction over French or German patents or indeed anybody else's patents. It's merely deciding on what basis it should go ahead and grant an injunction. Now, if it goes ahead and does that, it sets, let's say it determines that a global FRAND rate for a portfolio is €1, and if the implementer pays €1 per device, then there will be no injunction in the UK. The implementer's got that choice. It can say, you know what, the UK is a small market now. It's not really part of the European Union. We don't really care. We won't sell there anymore. We will concentrate on our primary markets of Germany and France. In which case, the English court's decision is irrelevant. There can be an action for infringement in Germany or in France, and the French courts get to decide completely from scratch what is a fair, reasonable, and non-discriminatory license, whether they should go ahead and grant an injunction or not. So the English court decision will then be irrelevant. The alternative situation is that the implementer says, okay, I'll sign up for a license on those terms for now, obviously, because in 3, 4, 5 years' time, whenever this license expires, then I may take a different view, and I may say that actually I've established that many of these patents in the meantime are invalid or not infringed, and that the license term should be lower. In which case, it's free to do that. But in that situation, of course, the patent owner can't sue in France or in Germany, so there won't be a case before the French and German courts. That's the where they are having to decide whether the English court got it right or not. So I don't think that Brexit changes this, and equally I agree with the Supreme Court that this is not the English court exercising some sort of jurisdiction that that it feels that France and Germany should follow.
Okay. Next one is, the court states that the implementer can request a license from the SEP owner by enforcing the friend contractual obligation on the SEP owner.
Yes.
Does it mean that the SEP holder cannot choose where in the value chain can he license? And what happens with the exhaustion issue?
Yes, there's been, I've already seen a number of people looking through the judgment. In fact, this is one of the Keystone articles as well. People looking through the judgment for comments and phrases that might support the license to all or licensing level dispute that's going on with Nokia and Daimler and Sharp and Avanci in Mannheim and in Munich and in the United States. I don't think you should read the judgment in that way. That question wasn't before the Supreme Court. They won't have had it in mind when writing their judgment, and there may well be sentences in there that could be read one way or another to support or oppose that argument. But because that wasn't before the court and they weren't deciding it, the sentences and the way you might read them would have no authority at all. They wouldn't be part of what we call in the UK the ratio of the judgment. And therefore they don't carry any weight. There are quite a few instances where you read through where you think actually the Supreme Court has expressed that wrongly. One point where they say on many occasions that the operator is entitled to demand a license, or the operator should take a license, which of course in Vodafone and IPCOM, the big question is, should operators take licenses? But they're not using operator in the sense that we use the word operator in the telecoms industry. They don't mean mobile telecoms operators. They mean implementer or manufacturer. So I think you should be a little careful about reading it, looking for things that are not part of what was being decided, because you will inevitably find language that supports one way or the other, but is not at all what the judges had in mind.
Okay. Related question, will this affect the disputes in the auto sector?
I think that it might. We haven't seen a dispute in the auto sector being filed in the UK yet. There's been several other FRANS type actions filed in the UK. So Philips has been using the UK court. We had TQ Delta and Zexcel, Mitsubishi and Sisvel have all brought actions in the UK that relate to mobile phones. But the auto sector actions have all so far been in Germany. And I think the reason they've so far been in Germany is because the disputes in the auto sector tend to be about rather lower levels of royalties, not in the sense that the royalty per vehicle is lower, but far fewer cars are sold than mobile phones. So the amounts in dispute are less, and the German court is quicker, cheaper, and is probably more proportionate for lower value disputes. But a couple of things have happened there. So first of all, the German court hasn't proved to be quite so quick as it has been in previous years, and many of these Nokia Daimler cases are taking a year or more. It's not necessarily proving to be cheaper because the disputes are being very hard fought. And it's also now with this bond that's been set in the Nokia Daimler case for 7 billion. A 7 billion bond to enforce an injunction might be manageable for the Nokias and the Ericssons and the Qualcomms of this world, but it's probably not manageable for the vast majority of SEP-owning companies. So I think you might start to see people think that in the German court, it's not quite so quick or cheap, and it might not realistically be possible to enforce an injunction in the auto sector until you've got to the appeal level, which makes it even slower and more expensive. And now the English court has settled on this and put in some degree of certainty. It might be that we start to see auto sector cases now filed in the UK as well. It's the balance may now favour the UK courts a little more than it did in the past.
Okay. So follow-up question, do you think there will be more patent sales to patent assertion entities following this decision? I
actually don't. The thing that drove a lot of patent sales, well, a couple of things drove a lot of patent sales to patent assertion entities, or the secondary market is probably a better way of putting it. The first was that companies who were selling them were in a financially difficult situation. If you look at Nokia's sale to Conversant, it's around the time of it exiting the mobile phone business. It's around the time of it having a serious cash shortage. Eric, well, obviously exited the mobile phone business. And back in 2013, it was very difficult to monetize SEPs, and many people were operating on the basis that realistically you can't assert SEPs because you can't get an injunction on them, and the most you can get is effectively country by country damages, and you would have to sue by country, and that wouldn't be possible. And so they were divesting of SEPs because they saw that there was no practicable means to enforce them. Now the world has changed. We've had several courts in several countries finding that you can get injunctions under SEPs, and going ahead and awarding injunctions when parties haven't given or haven't accepted FRAND offers. So we've seen many cases in Germany, we've seen cases in China, we've seen cases in the United States, and now we've got finally the confirmation from the UK that is possible. So now it is reasonably practical to monetize SEPs and to bring a reluctant implementer to court if he doesn't do so. So all of a sudden the incentive has changed. There's no longer an incentive to divest these SEPs and try and monetize them through sales price. Now, if anything, the incentive is to hang on to them, to boost your portfolio so that when it gets into some sort of court-determined FRANS dispute, you have a large and strong portfolio, which means that on a top-down analysis or a comparables licenses analysis, you're going to do better. So I think actually this has the opposite effect. I think it reduces the incentives to divest patents, and we may see fewer patents being sold off in this way.
Okay. And do you think that other courts outside the UK will now start determining global FRAND rates? And in addition, do you think that we might face ping-pong game between like Chinese courts and European courts giving anti-suit injunctions and anti-suit injunctions, etc.?
Well, on the question of whether we'll see them starting to determine, I think we already are seeing them determining FRAND rates. The German court, in assessing what is FRAND and whether or not to grant an injunction, does do this. It doesn't go as far as Mr. Justice Burse in actually working out for itself what the FRAND rate is if it falls somewhere between what the two parties have done, but it does determine FRAND. And jurisdictionally, that is no different. We've also seen German courts in Dusseldorf suggesting that what it could do is they could say to the parties, you've offered 1%, you've offered 0.1%. I think 1% is possibly not FRAND. I think 0.1% is possibly low. I think that we should hold another hearing and both parties should be able to go away and reconsider their offers. And that is almost, well, effectively the same as what Mr. Justice Burse has done. Mr. Justice Burse has told them the answer. The German court is suggesting that what it might do is act as a sort of quasi-mediator role and give the parties a second chance to get it right, which is not very different. And then, of course, you look at Huawei and Samsung in China, and there's a very extensive and careful judgment where they analyze the Huawei rates, they analyze the Samsung offers, and they come to the conclusion as to whether these global offers are FRAND or not. So courts are already doing this. Will this cause more of them to do it? I suspect that, well, I suspect they will carry on as they are doing, and I suspect we will see a bit of a race to the courthouse where companies who want, companies who think that one particular court will give them a favourable rate will try and get their actions brought there before others manage to bring them before what they see as more patent-friendly courts.
Okay. Next one is this decision good news for consumers or bad news?
I think it's good news for consumers in that a more consistent FRAND regime means that there will be fewer disputes. People will spend less money on lawyers. It means that parties are more likely to be able to reach agreement. It also hopefully means that there will be a greater degree of licensing. So you you won't have this situation where half the market is unlicensed and therefore able to sell undercut the other half of the market which is licensed. So with a more level playing field, I think you'll see more fair competition. Longer term, of course, you'll see more money hopefully coming into R&D. And the best news for consumers is that what we've seen with the evolution of the standards is that the price per bit of data being transmitted and received is falling all the time. So nowadays I pay pretty much the same for my mobile phone as I did back in the 1990s, where I had a 2G GSM mobile phone sending and receiving text only, but what I'm getting is so much better. And so hopefully in the long term we will see that we will see more R&D, and we will see better data rates and cheaper data for consumers. In the short term, we may see more people paying royalties, but I don't think that will immediately be passed through to consumers. I think there's enough elasticity in the price of the handsets that the prices at which the handsets are being offered to consumers is not dependent on the BOM costs, the component costs, and the royalties that are being paid. It's set on what the market will bear. And there is, in the case of some handsets, a very substantial profit margin, which is not going to be particularly affected by a small increase in the royalties.
Okay. As we had a small technical issue and some delay, would you agree to have a few more questions?
Yes, and I apologize for that.
Okay, great, thank you. Next question is, do you believe the decision will have any effect on the enforcement of most favored nation clauses in existing licenses?
In the enforcement of most favoured license, I don't think that was really a part of the ETSI obligation. I think that was one of the findings of it. I think that one of the things we may start to see is a little bit more transparency in rates. We're already seeing a tendency towards that with people like Avanci effectively publishing their rates and saying, here it is, this is the price. And one of the things that the Supreme Court has said is that there are more, each patent owner should effectively operate from a rate card which is the same for everybody, and you shouldn't have more favourable rates for particular people. So I think we may see a little bit more of a level playing field as people start to recognise that. I think many of the big licenses already operate on what is effectively a rate card, even if it's not published, but we may see more consistency of that.
Okay. The next question is quite long, so I will try my best to read it correctly. How is compatible the statement of the court that parties understand that many patents are invalid and not infringed, which is considered in the licensing agreement, with the right of the implementer to require that the license provide a mechanism to alter the royalty rates as a result of patents being infringed? And it continues and it says, how would this be considered in negotiations of large portfolios with new patents constantly being granted during the period that the licensing agreement lasts?
So this actually was one of the things that I was really pleasantly surprised by when I listened to this. People who have operated in the industry know that a large number of patents aren't valid, infringed, essential. There are various reasons why they're there in the portfolios, and if they're not infringed or essential, cynics say it's to boost up the numbers to make you look better in licensing. Other people say it's because, for example, the obligation to declare is to declare things that may be or may become. So over-declaration is merely being conservative and playing the game as it should be played. But the result is that not every patent in a portfolio is valid, infringed, and essential, and in fact the rates might be relatively low. One of the first things Lord Hodge said in his video summary was to acknowledge this. He says that everybody knows this and the prices are set accordingly. And when he said that, I breathed a huge sigh of relief. I thought, finally, somebody gets that point. The price that is set based on the fact that we know that not every patent in a portfolio is valid, infringed, and essential. Now, if you're licensing a small portfolio, 4 or 5 patent families, then if one of those is not valid, infringed, or essential, that might make a bit of a difference to the rate. if 2, if 3, if 4, that makes a really quite significant difference to the rate. So if you're negotiating a license for a very small portfolio and you can't agree between you the strength of the portfolio, you might well include a clause that says something along the lines of, if this one is upheld in the EPO, then the rate will be a little bit higher. And in my career, I have done that on at least one occasion. We have had licenses where the amount that is paid does reflect the outcome of the EPO proceedings. But when you're dealing with a large portfolio, that becomes impracticable. If you're looking at sort of the Nokia or the Qualcomm or the Ericsson portfolio, let's assume that the number that is valid, infringe, and essential is 50%, not because that's right, but that's just because an uncontroversial number that either side might not argue. In order to demonstrate that the rate should be lower, you would have to knock out more than 50% of the other side's patents. And when you're dealing with portfolios of thousands, that is prohibitively expensive and is likely to take longer than the few years duration that these license agreements have. So I think if you're dealing with a large licensing portfolio, it's probably not realistic to have in it a clause that says that if some patents are found not to be valid and infringe and essential, the rate will be renegotiated, because the reality is that to get to that stage is so prohibitively expensive and takes so long that you just won't get there. It's much more sensible to have a license agreement that is for 5 years or 4 years or whatever. And then when the renegotiation comes up, you can take into account what's happened after that relatively short period of time.
Great. Next question is, do you think the court would have arrived to a different outcome if the defendant were domiciliated in the EU instead of China?
There would have been a different test then on forum conveniens, because we would have started to have the Brussels regulation and things like that applying. I don't think the outcome would have been different. I think the outcome would probably have been the same. But I think there are different things that arise or different arguments that arise when they're within China. In this case, they weren't successful, but they probably carried more weight because China was the domicile rather than the EU.
Okay. I think that we have covered most of the questions that we have received, and now time is up. So, Richard, I would like to thank you very much for this very clear, and I have to say that I love hearing your explanations because I can understand them. So that's great. And as mentioned before, the presentation will be made available on the 4IP Council website after the webinar. So at least give us a few hours. And also, please feel free to subscribe to our newsletter to receive updates on the relevant academic studies, the future webinars, and case law summaries. So final, thank you very much, Richard, for participating again to a webinar with 4IP. We are glad that you were available, and the slides will be made, I think, available in the next 20 minutes on the website.
Good. And I apologize to everybody again for the technical difficulties. I'm sorry, and thank you for the patience while you bore with us while we sorted that out.
It was definitely not your fault. Okay, thank you everybody for attending. It was really a pleasure, and we will have more webinars in September. So stay tuned and just check the website. You should be able to register very soon. You will have a survey when you will close the session. And if you have just 1 minute, please answer the survey. That will help to make sure that the next webinars will be as useful as today's webinar. Thank you, and have a good afternoon or a good end of the day.
Thank you very much.